Oh boy, where do I begin? Where do I begin?
On the Sixth Amendment, if I'm not able to face my accuser, then how can a claim be brought against my client if I'm not able to face the accuser?
This trial is emotionally draining, and I'm just watching it. I'm just a spectator on YouTube watching the trial as it unfolds, and it's emotionally draining. And I know it's emotionally draining for the prosecutors. It's emotionally draining for the judge. It's emotionally draining for the witnesses that have to testify. He constantly is asking for the plaintiff. Now he wants the plaintiff, he wants to interview the plaintiff. He wants the plaintiff in court. Okay, if that makes sense to you.
Mr. Brooks, I'm reviewing this for completeness, and you have simply put on here state of Wisconsin plaintiff. That's an entity. You have to name a person, sir. The date we would fill in. So I'll have it shown to the state, and they can let me know their position on that.
Legal basis why that would not be accepted, Your Honor.
You have to have a person named, sir, so that they can come and testify. You only have an entity named.
Is it not true that under the Sixth Amendment I have the right to face my accuser?
Mr. Brooks, let me hear from the state.
I want to reveal that's very telling is his social media. I went through his social media. I went through his Twitter. We're going to get into that in a second. Did you know he was a gang member? Did you know he's a gang member? It right there. But we're going to get into that a little later. He's requesting for the plaintiff to be at the trial, the state of Wisconsin. He wants to question the state of Wisconsin. The state of Wisconsin is an entity, is not a human being. The only people that he can question in this trial is a human being. But take a look at the judge. Take a listen to this.
Assessment, the subpoena does not state a person. The subpoena form specifically indicates that the person requesting the subpoena is to indicate the witness's name and address. Mr. Brooks has simply written the word state of Wisconsin plaintiff for the witness name. The state of Wisconsin is an entity, it's not a person. The state of Wisconsin cannot testify at these proceedings, so the subpoena should be rejected, Your Honor.
Your Honor, on the grounds that every document that was filed in this matter stated that the state of Wisconsin was the plaintiff, which would lead me to believe that the state of Wisconsin is who's bringing the claim against my client. How could they not be subpoenaed to testify if they're the plaintiff? And under the Sixth Amendment, I have the right to face my accuser. My accuser in this matter is the plaintiff, which is the state of Wisconsin. Attorney Opper also brought up that it didn't have an address on there. None of my subpoenas had addresses, as we went on the record, and that was stated that a lot of the paperwork that I have don't have a lot of the people's addresses on there, and those subpoenas were accepted. So I don't see the difference with this subpoena not being accepted for the reasons that Attorney Opper just stated.
Mr. Brooks, in relation to that subpoena, based upon my review for completeness, this court would note you have not named a person, you've named an entity, and the subpoena will be kept on file as part of the court record, but I'm not going to require the state of Wisconsin to testify in this case because they are an entity and you have not named a person.
Are they not? Or are they not the plaintiff, Your Honor?
They are the plaintiff in this case, sir.
And why are they not able to testify, being that they...
Sir, you've named an entity, not a person. People are called to the witness stand to testify. You have had an opportunity to cross-examine every single person who has been called by the state to testify in this trial. I believe that your Sixth Amendment rights have been complied with.
Not if I'm not allowed to face my accuser, Your Honor. My accuser in this matter would be the state of Wisconsin. And with all due
Sir, I believe your
respect,
Sixth Amendment rights in that regard have been complied with.
I'm requesting a written judicial finding of fact and conclusion of law on this issue for the grounds that I just stated. It was seen, based on the Sixth Amendment, that I'm not being awarded the chance to face my accuser, which I should be awarded that based on the Sixth Amendment. If I'm not able to face my accuser, then how can a claim even, how can a claim be brought against my client if I'm not able to face the accuser?
So this case is a criminal case in a court of competent jurisdiction in the state of Wisconsin, Waukesha County. This case was initiated initially by the filing of a criminal complaint. Then there was a preliminary hearing where probable cause was found. After that point, there was an information that was filed. And at some point, an amended complaint, perhaps even a second amended complaint, was filed as well, putting you on notice of the charges and the factual basis for those charges, along with the statutes that are alleged to have been violated. I'm not going to explain any further why you can't call the state of Wisconsin in the way that you've subpoenaed them or attempted to subpoena them for the reasons I've already stated. I understand where you might disagree with the court's ruling, but my ruling stands, and I'm not requiring the plaintiff in this case to serve that subpoena in any way for the defects I've already noted.
May I state for the record?
And I'm also not going to issue a written decision on that. The record speaks for itself.
May I state for the record, Your Honor, that I have not even seen a complaint in this matter, and the jurisdiction still has yet to be proven, which is another thing that needs to be challenged. There has not been proven that there's subject matter jurisdiction as of yet. There's no verified proof of it. There's no verified proof of even a claim, especially if I'm not allowed to face my accuser. And I don't understand how you can make that judicial decision, Your Honor, when it's clear discrepancies in the paperwork of this matter. Like I said, I have yet to see jurisdiction be proven. It has not been proven. I have yet to see a complaint. I have not seen that.
The court has provided you with, I believe it was the second amended criminal complaint, along with the information that was provided to you previously and noted on the record. I've already addressed your motion to dismiss.
Already said he cannot have the state of Wisconsin as a witness, and he just continues to go on and on and on and on. What he's doing is he's just, in his mind, I had said this in a previous video, he know exactly what he's doing. Don't look at him as someone that's not knowing. He doesn't know much about the law at all, and we all can agree to that. He doesn't care about that. And the law is it's crazy to request a plaintiff to come in to question him. And he should know that an average lawyer would know that. This is not something that is normal in court. But he's not a normal person. He thinks that, okay, well, this is what I think. And I think, Judge, you should make a ruling on it. No. That's not going to happen. That's not going to happen. It's just delaying the inevitable. Okay? Now, I want to get into what he's being charged with, right? Let me just read this briefly. Okay, Darrell Brooks, he's being charged with 6 counts of first-degree intentional homicide and 6 counts of committing a hit and run causing a death, according to the court documents. He's also facing two charges of felony bail jumping and 67 counts of first-degree endangering the safety with a dangerous weapon. The reason why they charge him with that, because he used his vehicle. Again, 6 counts of first-degree intentional homicide. Intentional. Was this intentional? Now, his defense strategy, he's probably going to say this wasn't intentional. Maybe he say it wasn't really him in the vehicle. Well, here's the thing. In the trial, they showed a still photo of him in the SUV. And then it was crazy when he got arrested. Take a look at this arrest, and it looks just like the still image of the SUV. Take a look at this.
Hey, I called an Uber, and I'm supposed to be waiting for it over here, but I don't know when it's coming. Can you call it for me, please? I'm homeless. My ID.
Okay, you see that, right? So you see the image of him on that Ring doorbell that matches the image of the gentleman that was in the vehicle that hit these people. If this was a mistake, if this was an honest mistake, whether it was brake failure, he would have stopped. But no, he tried to flee. He tried to run and he got caught. I'm thinking this is intentional. I'm really thinking this is intentional. Now, we're going to go to, he's a gang member. Oh yeah, he's a gang member. Before I do that, let's just, let me just show you a few things in his Twitter. Now, his Twitter is very telling. Okay, he talked about Kyle Rittenhouse. He talked about Obama. There's some other things in his Twitter as well. I don't know if this is going to be introduced in court. I really don't know. It might be introduced in court. I think, in my opinion, they still have a long way to go because he's just dragging us out with his questioning. And then also he noted when he present his case, he has at least 13 witnesses. One of them is the plaintiff, but maybe it's 12. Take a look at his Twitter. It's very interesting. Take a look at this.
Live in the booth, you know, working. The big Early. Sprite. Red. Y'all already know, man. Yeah.
Okay, so you saw his Twitter, right? You saw his Twitter. Now take a look at this this video here, Mr. Gang Member. Yeah, Mr. Gang Member. Take a look at this.
D-Mark got that heel.
I just got a load worth about a half a ticket. 30 in the blicker when I'm out here chasing chicken. Will it?
Noticed at the end, he puts up this gang sign, right? He puts up this gang sign, but in court, now he has a Bible in front of him. Take a look at this.
As a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. If you come in contact with the parties, the lawyers, interpreters, or witnesses, do not speak with them.
In times when people are on the inside, okay, when they know they're not going to get out, often find religion. Now, I'm following another case involving this cult leader named Nature Boy, Eligio Bishop. If you want to research him, his name is Eligio Bishop, aka Nature Boy. Now, he's on the inside when it looks like he's not going to come out. And now he is converted to Islam. Okay, a lot of people don't seem to believe it, but a lot of these people, they find religion. And I think I would probably find religion too. But the reason why I bring all this up about him being a gang member, because maybe some people don't know about his social media. I will leave a link to his Twitter because it's still active. I don't know if they're going to introduce this into evidence in court. Like I said, I think we have a long way to go, but I am definitely going to leave that link in the description so you can just take a look at his Twitter. Take a look at the things he were posting, and you make your own determination. And another telling thing in this trial, really a telling thing, but he was defiant today. Here we have a dad. His child was attacked for no reason by the defendant. Oh, he don't want to be known as the defendant. But at some point, during the questioning, he decided to stand up. It's almost like he's trying to be defiant. He's trying to intimidate. Take a look at this.
Can you point about where?
Again, I estimated at about 20 feet. So
would it be fair to say that halfway between you and I would not be an accurate statement of 20 feet?
Objection.
Grounds.
Overruled. He may answer the question.
that's why I say that it was about 3/4 of the way.
So about what spot would it be? By this black, I guess, I don't know what that is. I don't know if that's a door.
I'm gonna give the dad, really, I want to give him credit. He was strong considering what he has been through, and like he said, his daughter had to go through surgery, and all this is for no reason, just because a lunatic decided to. It's like I can't even begin to understand why he did this. But I was looking through his social media, and I honestly believe, let me just tell you, I'm just going to end this. I'm not going to take much more of your time. He is going to be found guilty on everything. He is hurting his case for first degree. They're going to give him first degree. They're going to run the table on this, the state. And the state, they can probably at this point abbreviate their witnesses because he's making it matters worse for himself. He probably should have just kept his attorneys, and maybe he would have had a chance at not getting convicted on first degree. But he's going to spend his natural life behind bars. Trust me. It's just a matter of time now. He's just trying to delay the inevitable. With all these on grounds this, grounds that. He's going to be convicted. Remember, I made a prediction here. He's going to be found guilty on everything, and it's not going to take long for the jury to deliberate. What say you? Drop a comment below. Let me know how you feel. And also, like I said, his Twitter link will be left in the description, so you can take a look at it for yourself. All right, guys, let me know how you feel about this case if you're watching it so far. All right, guys, see you next video. Peace. Hey guys, if you liked the video, please do me a solid. Please do me a favor. To be greatly appreciated by me if you liked the video, if you got something out of it. We're trying to reach a milestone on the channel at 20,000 subs. We're almost there. Please subscribe. Please give us a like. Please share. And if you've done so already, I'm greatly appreciative of that. Thank you so much. And so we're going to get there. So help us get there. And so, yeah. All right, guys. Thanks for watching. Peace.